So welcome to the seminar that's being held this term, which is hosted by the Program on Education Policy and Governance. I'm Paul Peterson. I'm the director of the program. And I'm very pleased today to have two excellent students of American politics and American education and American law speaking together, which makes for a more dynamic session than ever. It's really a great pleasure to have here today Joseph Olchefske, who was the superintendent of the Seattle school system at the time that it underwent a desegregation program and diversity program that really was transformative for the city of Seattle. And also to have, at the same time, the former law clerk to Stephen Breyer, who was sitting on the court at the time that this very case came to the Supreme Court, Thiru Vignarajah, and Mr. Vignarajah has a law degree from Harvard Law School, which of course is the crowning moment of his life. You understand that. But he did go to Yale University as well, and he did serve as a law clerk for Justice Breyer. And he also ran as a Democratic candidate for the mayor of Baltimore. So, and most importantly, he served as Deputy Attorney General for the state of Maryland. So he's had a lot of experience in the law and politics, and has thought deeply about the issues of school desegregation and school diversity, which is the primary topic that we will be discussing today. Joseph Olchefske also attended Harvard, this time in the Harvard Kennedy School, earned his master's degree here, and is currently on the faculty of Johns Hopkins University School of Education. So I think, how are we going to begin? Who's going to begin first? Superintendent Olchefske, would you take it away?
Thank you. The real honor to be here. I know we also have an audience online, so online. Slides. Not quite sharing yet. There we are. Okay. Great. Maybe you're going to have to. There you go. Well, Professor Peterson has already done the first item on our agenda, which is to welcome you and give introductions. What we want to talk about today is Thiru is going to give you a context of desegregation law, very briefly, but it really sets a context for what school districts all over America were responding to and are responding to today as they plan their student assignment. Right? The topic of assigning students to schools is fundamentally a highly complex, technical, algorithmic process in every school system. And it's fraught with politics and policies, and it's fraught with intense parent interest because parents want their kid to go to the school the parents want the kids to go to, regardless of the algorithm and the technical and the computer program. Okay, so Thiru is going to give a brief history of school segregation law and Supreme Court cases. I will then sort of take you under the covers of Seattle Public Schools. I joined Seattle Public Schools in 1995 as Chief Financial Officer. The Student Assignment Department reported to me, and we were just ending a 20-year commitment to a desegregation plan, and we wanted to replace it with a choice-based plan. And me and my team were responsible for authoring that plan. I then became superintendent and had 5 years of sort of implementing the plan. So I want to talk to you about that. And then we were challenged in that plan by a group called PICS, Parents Involved in Community Schools. And the case eventually winded its way through the legal system and ended up at the Supreme Court. We won all the way and then lost at the Supreme Court. And so Thiru is going to give you some inside context to that legal course, that Supreme Court case. And then finally, we'll open it up for discussion, your questions on choice desegregation and its implications for other districts. So is this working? Oh yeah, there we are. Okay. I think Paul has already given this. We do have some Harvard bona fides. We just were talking to a group of undergrads, and Professor Peterson introduced Thiru as a Yaley, and he got roundly booed. So we do have some Harvard bona fides up here, and so I'm going to step aside, and Thiru's going to take us from here.
Thank you, Joseph. Thank you, Professor Peterson, for that warm introduction. Whenever you say a person ran for office, it means they didn't win. But I do appreciate the chance to talk about a challenge that faces not just places like Baltimore City, but cities and states across the country. The truth is that America's worst kept secret is perhaps that our schools, our public schools in particular, remain stubbornly segregated by race. What I think was remarkable when I was clerking in 2006 and 2007 was that Justice Breyer reported at that moment that America's public schools were more segregated at any points since 1968. What is tragic is that when we did an update to that dissent and published it as a book through Bookings, that in 2022, we had the inauspicious job of reporting that America's public schools are more segregated today than they have been at any point since 1968. Our schools literally reached a high water mark of integration in 1988 and have regressed ever since. What I want to do is explain how it is that we got there, and that although American people had a lot to do with where they moved and how they self-segregated, the Supreme Court's decisions at critical moments during that history shaped and precipitated the response and reactions of the American public. Everybody knows that before 1954, we of course had de jure segregation, segregation by law. Cities and states and municipalities were entitled to discriminate on the basis of race explicitly. In 1954, in this unanimous pronouncement by the Supreme Court, that was all supposed to change. It of course did not. Districts across the nation, particularly in the South, revolted. One conspicuous story that ultimately went to the U.S. Supreme Court in a case called Cooper versus Aaron is what happened in Little Rock, Arkansas. Governor Orville Faubus so strongly felt the Supreme Court could not compel desegregation in his state that he ordered the Arkansas militia to block the schoolhouse doors to Little Rock Central High School. It took President Eisenhower dispatching the 101st Airborne Division to Little Rock, Arkansas, and this elite brigade of paratroopers to accompany 9 Black school children as they sought to integrate Little Rock Central High School. Ultimately, things improved as a result of a trilogy of decisions in the late 60s, where the U.S. Supreme Court demanded that they remove and dismantle segregated schools root and branch. They insisted that the efforts in certain states were insufficient and put school districts across America under federal decree. And the result of that was between 1968 and 1974, you saw real progress. That progress was brought to a dramatic halt in Milliken versus Bradley, a 1974 decision where Justice Thurgood Marshall wrote one of his most impassioned and consequential dissents. In that case, the city of Detroit and the state of Michigan faced a problem which was being replicated across the country, where millions of white Americans were leaving urban centers to go to the suburbs specifically because of school integration efforts. That was further reinforced by federal housing policies and any number of other national factors, but that was a critical factor. And facing the Supreme Court was a situation where the city of Detroit and federal courts that were reviewing that situation concluded that they couldn't actually create integrated schools unless they compelled some number of white families and white students that had moved to the suburbs to be a part of the city's school system. Ultimately, the US Supreme Court in a 5-4 decision said, we will not order people that have moved to the suburbs to have their children attend schools in the city, even if it is for the purpose of more integrated schools. Justice Marshall, who had argued Brown versus Board of Education, of course, wrote an impassioned dissent where he feared in these ominous words, if our children do not learn together, there is little hope that our people will ever learn to live together. But those words were the words in dissent. And in the years that followed, integration dramatically slowed. And by the late 1980s, the Supreme Court actually removed the impediments for federal decrees to be lifted. And the Office of Civil Rights, an arm of the Justice Department, was then empowered to go from one school system to another, representing to courts that they'd come far enough, that they had achieved unitary status, and therefore in 1980 was the high point of integration in this country. In 1988, 37% of Black students in America attended a majority white school. In the years that followed, that number has been cut in half. In 1988, only 6% of schools in America had hyper-segregated Black populations, 98 to 100% Black. That number in the years since has tripled to nearly 20%. In practice, that means that there are today 4,000 more public schools that are 99 to 100% Black than there were the apex of integration in America. That is a sad situation, but it is the situation that the superintendent of schools in Seattle inherited, and he's going to tell you what they did to try to fight it.
Thank you, Thiru, and you're exactly right. This is the lay of the land that we inherit. And so let me give you a little tutorial, a little primer on the demography of Seattle and Seattle schools from a student's perspective. Okay, there's really 3 regions of the city in broad terms. North side, richer, whiter, fewer immigrants, and surplus school capacity, meaning there's more seats than there are kids. Okay, a product of the white flight that Thiru had. Okay, south is the mirror image of that. Poorer, more people of color, more immigrants, and deficit school capacity, meaning more kids than there are seats in the local area. Okay, again, a product of what Thiru is talking about. The people of color did not move to the suburbs, they stayed in their local area. Okay, and West Seattle, which in some ways is a standalone, is fairly balanced socioeconomically, and it's right-sized. The number of seats are about the number of kids, but the dynamics, the rich, poor, white, non-white divide kind of runs east-west there, with richer, whiter folks living near the water, or more kids of color living up the hills away from the water. Let me make a note, though, about race in Seattle. When Thiru talks about the history of those cases, it's all defined in kind of black-white terms. White population, Black population, how do you integrate them? That's far less germane to a Seattle environment today, and certainly in 1995. School district I ran was 40% white, 25% Asian, 25% Black, 10% Latino, and a meaningful 3% Native American. So we inherited this legal construct, which was kind of binary between white and black in a world that was very much a polyglot, crazy quilt of different populations. Also need to say, even within the defined characteristics I just gave you, white, black, Asian, Latino, there were Black families, middle-class Black families in our city that were college educated, and there were recent Eritrean and Oromo immigrants. Both of them checked the box Black. There were well-established Asian families, which were some of the wealthiest people in the city, and recent Tongan and Samoan refugees that were illiterate in their own language. They both checked the box Asian. There were white families like mine. I was a dad in the school system. But there were also, we were in 1995, we were dealing with the aftermath of the dissolution of the USSR. So we had Russians coming from, let's call it a lawless society, and they were some of the more violent populations in our schools. We all checked the box white, right? So this binary really didn't work for us. And frankly, so let me think about that. So here's our school system. Here's what a student assignment plan looks like if you're a school district. Prior to 1997, our goal was desegregation. And the fundamental premise was we were going to move the kids of color north, and we're going to move the white kids south. And I describe it that we were good at half that plan. We were really good at moving the kids of color north because they didn't have any options. The white families in the north side figured out lots of options. Workaround, gaming the system, lying on forms, misstating their address. Okay? We were moving kids of color north 10-1 relative to white kids we were moving south. So it's no overstatement to say the desegregation plan in those 20 years was built on the backs of kids of color in the South taking hour to hour and a half bus rides in the morning and an hour and a half at the end of the day. That was our plan. And we weren't moving the white kids south. As a result, the North End schools had artificially inflated enrollment. Remember I said those schools had excess capacity. All of a sudden they didn't have excess capacity because we were shipping in these kids from the South, and schools in the South End had lots and lots of empty seats, despite the fact there was an excess of kids in Davis. That was our plan. The plan I was very involved in authoring was a choice plan with a goal around diversity. In many ways, we weren't viewing it through the lens of desegregation. We were looking at it, and I said this to Paul in an earlier meeting, in many ways, we were growing out of the choice movement of the 90s, but we also wanted to acknowledge the educational value and the community value of creating diverse schools for kids. Okay? So any kid can choose any school. If there's an empty seat, you get it, period. There is no conversation about it. If more kids want a school that there are seats available, we had a system of tiebreakers. And we'll talk about that. We knew as soon as we made it open choice, those families, the minority families of color in the South End did not want their kid riding the hour and a half bus. They were going to start choosing schools in the South End. We knew that. We didn't know how fast, we didn't know which schools they were going to choose, but we knew that we were going to have this enormous migration of kids from North End schools to South End schools. We didn't know how fast, right? We didn't know the dimensions of it exactly, but we knew many, many families were dissatisfied with the existing. So, and we knew that was going to create very different compositions of school body and the profile of academic needs in those schools were going to become heavily immigrant, meaning ESL, from English as a second language, higher incidence of disabilities in special ed, higher incidence of poverty, clear indicators of educational need were going to get concentrated in the South End. So we changed our funding formula. Historically, our district, every district around the country had allocated resources to school based on stat, allocating FTE. We went to dollars attached to kids. Every kid had, some people call it backpack funding, had money attached to them that followed them as they chose a school, right? Importantly, we weighted the amount of funds based on demographic factors that were indicators of need: poverty, special ed status, disability status, severity of disability. So we had $2,500 kids, and we had $25,000 kids. Very significant income resource distributions. As those kids chose a school, we could with a straight face say, your money is going to follow you to that school, regardless of what school you chose. We also changed our staffing model to do away with bumping rights, which meant historically, if there was an opening in a school, the teacher with the greatest seniority got the job. And regardless of whether the school wanted them, whether it was a good fit for that school. And we said, no, the school should be able to choose teachers. I also, and this was a big part of my superintendency, I took control of principal appointments, and we had a long history of rewarding our best principals by assigning them to the easiest schools, otherwise known as the North End schools. That was your award. That was your career accomplishment. You get an easy school. And I said, no, we need to move our best principals to our toughest schools. And I started migrating talent from north to south. Okay, so these series of market-based reforms that clearly changed not only the composition of schools, but also programmatically what those schools were going to be able to do. Well, what was the impact of market-based reform? So here's the simplest shorthand way of understanding it. The North Side had to deal with the politics of scarcity. Scarcity of kids, because all those kids that used to be bussed in from the South End filling up your seats were gone. Scarcity of resources, because those kids took their money with them. And scarcity of student need. You might have a 5%, 10% poverty school in the North End, right? South was the reverse, the politics of abundance. Abundance of kids, abundance of resources, and abundance of need. The West, given that it was pretty balanced, really, it was the politics of continuous improvement. We could really focus there on addressing whatever students showed up at your school. So we could have South End schools have student-teacher ratios of 17-1. North End schools might have 26-1. Right? The best principals were now in the South End. Teachers tend to follow really good principals. So now, because any teacher can get employed by any school, the South End schools could now start recruiting the best teachers in the district because they had the best principals, lower class size, more resources. So dramatic changes. Tiebreakers. So all of this works well as long as supply and demand is balanced. The reality is when people make choices, they don't necessarily make choices in the neatest and tidiest ways. So, you have 300 seats available in a middle school and 400 kids want them. I had that incident. So in other words, I had to say no to 100 kids. Well, it's the school district's job to have the criteria in place that very clearly say why I'm saying yes to this 300 and why I'm saying no to this 100. Right? So we had tiebreakers. At elementary and middle schools, if you were a sibling of an existing student, you got in first. If you were in the immediate neighborhood, you got in next. If you increase the diversity of this school, you got in next. And then finally, distance. Well, increasing the diversity of the school. If the school was primarily white dominated, kids of color got in. If the school was primarily minority dominated, white kids got it. So it benefited both races, and the fact was we had both types of schools. We had schools that were predominantly kids of color that were very popular and white kids wanted to go to. We also had schools that were overwhelmingly white and kids of color wanted. So this tiebreaker benefited both. At the high school level, and this is where the court case becomes relevant, we didn't have neighborhoods. We wanted it to be a true open market of high schools. The reality is parents will have their kids travel a long way to get to a high school they want. So we didn't want to define it geographically. So it really was sibling followed by diversity, followed by distance. So here were our high schools, those red stars. All right, there's 10 of them. Some of them were popular, some of them weren't popular. Okay, every year we had to manage. It was a big task. We got the question at our earlier session. You know, this is an absolute mandate for a superintendent to focus on school quality to equilibrate choice. Because if you get a small number of very popular schools and a big number of unpopular schools, the choice data is going to reveal to you how huge your problem is. So, okay, we had choice, and siblings of existing students got in, and then in white-dominated schools, minority kids got in next, and in white-dominated schools, in minority-dominated schools, white kids got in next. Here are the 4 schools that were primarily white. And I forget the number. I want to say they had to be 80% white, I think, or something like that. Some number like that, maybe 75%, to trigger the tiebreaker. And then distance tiebreaker. So it just literally radiated out. So you're at this school. The school is called Garfield. And the siblings of every kid got in. Then every kid of color who applied got in. And then you started creating this concentric circle for white kids. Okay, that was the way the algorithm worked. And we did that for 4 schools. And in general, it was increase parent satisfaction with their schools. Except if you look closely at the map, you have that problem. Parents in this area can't go to this, white parents, I'm sorry, kids of color in this area can go to any one of those 4 schools. White kids can't go to any of those. Magnolia is the neighborhood, the whitest, one of the richest, most Republican enclaves in the city of Seattle. Right? Now, historically, ironically, people in this neighborhood had argued to go to Franklin. And every one of them would have gotten in if they chose Franklin. Because the diversity tiebreaker was triggered there. So every white kid got in to Franklin. They didn't choose it. They chose one of those other ones. Needless to say, they weren't happy. FYI, I live about here. So these were people I knew. These were kind of prominent people. You know, the editor, the managing editor of the local newspaper lived, right? I mean, I knew people then. And they sued, and the argument was the diversity tiebreaker. Were it not for the diversity tiebreaker, they would have gotten into those schools. And that was the case. Now this isn't working again.
So in a striking, maybe epic example of no good deed going unpunished, the success story of Seattle resulted in one of the most consequential Supreme Court decisions in modern history. When I was clerking for Justice Breyer, it became very clear early on that this was a decision with dramatic and far-reaching consequences. The plan was so popular in Seattle because it married this choice model with this diversity mandate. You had Republicans and Democrats. You had a lot of different people excited about this approach. That there was a
I said
time.
at the earlier meeting, our little bumper sticker was, this is a Republican solution to a set of Democratic problems.
Right. And it was so popular that for a time, one of the challenges in bringing this challenge is they couldn't find someone who actually had standing to bring the challenge. There are people that had philosophical objections to it, but nobody who was actually a parent who had a child that faced a consequence as a result of this, because the overwhelming majority of parents and kids were getting their first choice. But ultimately, they created, manufactured really, parents involved in community schools, an organization that was deemed to have standing to bring this challenge, and it went all the way up. As Joseph mentioned before, every challenge beforehand had failed. But by the time it got to the US Supreme Court in 2006, 2007, a number of things had changed, most conspicuous of which was that Justice Alito and Chief Justice Roberts were together for the first time for a full term on the US Supreme Court. And that would unfortunately mean that Justice Sandra Day O'Connor, who had been the principal author of the Michigan affirmative action cases, in which she declared that diversity was a compelling state interest, and so long as race was one of several factors, it was permissible to pursue integrated higher education. She, of course, was no longer there. And all along, there was a worry that Justice Kennedy, who ultimately did cast the deciding vote and struck down plans both in Seattle, Washington, and a companion case in Louisville, Kentucky, was going to happen. It was hard to fully appreciate why this was so personal for Justice Breyer, until one knows that Justice Breyer was the product of an exceptional public school in San Francisco, that his father was the lawyer for the San Francisco School Board, and that he appreciated as much as anyone those fateful words that I mentioned before that Justice Marshall had said in Milliken versus Bradley in 1974, that if our children do not learn together, there is little hope that our people will ever live together. And seeing a country still divided by race, still segregated by socioeconomic condition, Justice Breyer appreciated the difficulties that cities and states would have in creating more integrated forms. Ultimately, Justice Breyer issued an opinion that was, as he has described it, one of the defining opinions of his career. It was a 77-page dissent. And if you ever visit the Supreme Court for one of the days in which the decisions are rendered, you will hear the author of the majority opinion give a quick summary of the decision. And the moment that he ends is when the decision is rendered and it goes public. In a very small number of cases, typically because the dissenting justice feels strongly about the importance of the dissent, the justice will read from his dissent. Justice Breyer took a tone when he read from this dissent that Linda Greenhouse, the New York Times reporter with the New York Times, said was the most impassioned he had ever seen, as she had ever seen Justice Breyer, who is, I fondly would describe as a cool, keen, professorial type. But he started that dissent reading with a dramatic beginning. Said Justice John Paul Stevens, Justice Ruth Bader Ginsburg, Justice David Souter, and I dissent. And for 22 minutes, the longest oration, according to Linda Greenhouse, in the history of the Supreme Court, he spelled out the fall from grace that the Supreme Court would experience by rendering a decision that was so at odds with its history and recent precedent. Remember that the things that were happening in Seattle and Louisville were things that were ordered to be done by the US Supreme Court in earlier decisions to achieve integration. In the wake of Brown versus Board of Education, when school districts couldn't get their act together, the Supreme Court compelled districts to use, for example, busing. And busing, of course, was race conscious. Certain Black kids had to go to certain schools and certain white kids had to go to other schools. So for the purpose of achieving integration, the very methods that Seattle and Louisville were employing were not just permitted by the Supreme Court, they were required. Chief Justice Rehnquist, a famous originalist and conservative on the court who preceded Chief Justice Roberts, in fact, had written an opinion, a unanimous per curiam decision, a decision that was not even considered controversial enough to warrant a full rendering, in a case out of Seattle had said, though there may be times when we will not force a district to do this, if a district were to voluntarily adopt measures that were race conscious to achieve integration, then surely we would be permitting them to do it. It wasn't considered a colorable argument. But by the time it got there in 2006 and 2007, the personnel of the Supreme Court had changed. The complexion of the country had changed. And the result was a 5-4 decision where Justice Kennedy did agree with Justice Breyer and Ginsburg and Souter and Stevens that diversity was a compelling interest. The second half of the famous Supreme Court test was satisfied, but he concluded that they hadn't done it in a narrowly tailored manner. That even though it was only one factor of several, exactly as Justice O'Connor had instructed in the Michigan cases, that wasn't good enough. I'll dwell on just a couple of dimensions of the decision. I've sort of outlined a number of features in a book that Brookings published that is an edited reprint of Justice Breyer's full opinion with a long introduction that highlights a couple of, I think, critical features. Because Justice Breyer's opinion took on more than not just this particular case, but a couple of the moves that Chief Justice Roberts was making. One of them was to draw this sharp distinction between de facto segregation and de jure segregation. Segregation in fact versus segregation by law. The justice noted that the history of this country didn't allow such a sharp distinction to be drawn, because in places like Seattle, it was technically de facto segregation, but there was a number of policies that allowed it to occur. That in fact, Seattle, before the case that came to the Supreme Court, was worried about litigation, and therefore they adopted measures to make sure that they didn't have de jure segregation. The justice also took on this distinction about what level of rigor should apply when the goal of a state measure is to create more integrated schools rather than more segregated schools. Of course, the amendments that came out of the Civil War were meant to bring people together. So if Seattle adopted a set of policies with that aim to bring people of different races together, then surely that should be subject to a different level of scrutiny than a policy by an employer or a state to keep people separate by races. In the end, Justice Breyer appreciated the consequences of this and wrote in his opinion that he feared for the nation. If you read a dissent by Justice Breyer, he typically ends in the same way. He says, for these reasons, I respectfully dissent, or I respectfully dissent for the reasons set forth above in this opinion. That is not how he ended this decision. I'm just going to read for you the close of his dissent. Finally, what of the hope and promise of Brown? For much of this nation's history, the races remained divided. It was not long ago that people of different races drank from separate fountains, rode on separate buses, and studied in separate schools. In this court's finest hour, Brown versus Board of Education challenged this history and helped to change it. For Brown held out a promise. It was a promise embodied in 3 amendments designed to make citizens of slaves. It was the promise of true racial equality, not as a matter of fine words on paper, but as a matter of everyday life in the nation's cities and schools. It was about the nature of a democracy that must work for all Americans. It sought one law, one nation, one people, not simply as a matter of legal principle, but in terms of how we actually live. He had earlier said, yesterday, the plans under review were lawful. Today, they are not. Yesterday, the citizens of this nation could look for guidance to this court's unanimous pronouncements concerning desegregation. Today, they cannot. Yesterday, school boards had available to them a full range of means to combat segregated schools. Today, they do not. His final sentence in this opinion was the one dissent where he omitted the word respectfully. Instead, he closed by saying, "This is a decision that the court and the nation will come to regret. I must dissent." Unfortunately, what Justice Breyer feared has continued to come to pass. Our schools today in places like Baltimore, but truly in municipalities and states across the country, are more all white and all black than ever before. It is a problem that fuels the tensions when it comes to race relations. It is a problem that fuels the inequities in school performance. It is a problem that we all have inherited and that you all will have to go and fix. Joseph did his part. He took his best swing and he made some progress. And it was unfortunately the Supreme Court, the very Supreme Court that had pledged and made a promise to the people of this country that we would have more integrated schools. That promise is the one that has been broken, that you will have to ultimately help heal. Thank you for this time, and we'll now open it up to some questions.
So, do we have any questions, Marty?
So I'm very excited for the opportunity to ask this question in particular because I've taught this case for years.
You have to be worried when Marty says, he's excited about it. Can you get worried now? Okay, I'm used to this.
No, this is the question that I've been asked dozens of times by students over the years. We've never known exactly how to answer. So students reading about this case often find something a little bit compelling about Kennedy's sort of concurrence, in that they very much agree about extending the diversity rationale from higher education into the K-12 setting, but there's something about the design of these programs that seems too clumsy or just not adequate to live up to that rationale. So they sort of say, we'll grant you that this is a compelling interest, but I'm not sure it was narrowly tailored enough or done right, to use the language of the court. And one of the things they point to in particular, Joseph, you touched on it, is how the white, non-white binary was not a good fit for the demographics of the district. And the majority opinion actually, plurality opinion actually points to some examples of a school that wouldn't have been considered diverse, and it looks quite diverse according, if you break out all the categories. So clearly this was consequential for the decision. So why was it designed in this binary way? Is that because you were trying to capitalize on the fact that these were the types of programs that had been ordered on districts in prior remedial desegregation cases, and you just wanted to stick to that model? Or was there another rationale?
Well, when you run a school system, you don't get to pick the laws you inherit.
Yeah.
Right? You don't get to pick your parents. You don't get to pick the laws you inherited. We inherited everything that Thiru said at the beginning, and the history of student assignment, the history of desegregation law in America was a binary model. That's what we inherited. So we had to sort of frame in some way that.
So you wanted to rely on that order.
Correct. Correct. And at the same time, though, we really didn't see this as a desegregation plan. We saw it as a diversity plan. That was our goal. In many ways, we were playing off of the burgeoning choice movement that was arriving in America's schools, and we said, okay, we embrace choice. I mean, it's a very sort of Seattle value, but simultaneously, we said we wanted to value diversity. So, we saw it very much in that context. At the same time, the thing that irritates me to this day about the ruling is, so they accept diversity as a compelling interest, but this wasn't narrowly tailored. It affected the diversity tiebreaker affected maybe 3% of the assignments we made in any year. Maybe. You know, some schools more, other schools not at all. But I mean, it was in a school district of 50,000 kids, it affected a few hundred assignments. If
Plurality takes advantage of that to say that it's that important, why aren't you doing something more aggressive? Right? So
because you guys are going to ding
us.
us for saying it's not narrowly tailored. So if this isn't narrowly tailored, what is? And I, that's, you know, I'll go to my grave not understanding that logic. Because, you know, this wasn't a sledgehammer. This wasn't, you know, a broad-based swing. The plan we were moving from was a sledgehammer. So anyways.
Can I amplify that point in a couple ways? So one of the things that I would say to your students is, so what are the distinctions that would be permissible? Can you distinguish between Sri Lankans and Indians? Can you distinguish between one part of East Asia and another part of Asia, or between East Asia and South Asia? And there is a difficulty when you start recognizing the importance of diversity, but also realize that there's a lot of different axes of diversity. In fact, as Joseph explained earlier, even in the way that the money was sent to different schools through the individual, there's a lot of factors that were built into that to try to acknowledge the difficulties in educating a child from a particular background versus another background. And I think the question that I would put to your students is, who gets to wrestle with that difficult task? Is it judges and justices, or is it elected school boards and appointed superintendents? You know, it's always struck me that when people talk about sort of judicial activism, that the idea is, oh, does the court strike down, or do they go farther than the Constitution allows? I think there's a much simpler concept of judicial activism, which is, do you interfere with the decisions of democratic operations across the country? And I'm just going to read a passage that Justice Breyer actually put exactly to this question. And it reflects a genuine and personal humility of Justice Breyer, but also sort of what he believes is the design of the court versus a school district. He says, I do not claim to know how best to stop harmful discrimination, how best to create a society that includes all Americans, how best to overcome our serious problems of increasing de facto segregation, troubled inner city schooling, and poverty correlated with race. But as a judge, I do know that the Constitution does not authorize judges to dictate solutions to these problems. Rather, the Constitution creates a democratic political system through which the people themselves must together find answers. And it is for them to debate how best to educate the nation's children and how best to administer America's schools to achieve that aim. This court should leave them to their work. I think that is the answer about how you draw these distinctions, because I don't know either whether Sri Lankan Thiru should be put in the same category as South Asian, another South Asian. That is the difficult task that we elect people and appoint people to do.
Could you also expand a bit more about how you dealt with different stakeholders? Because this is all very interesting to me. And in most of the policy classes that I've been attending, we talk a lot about negotiation.
Yeah.
So how has your experience been?
Well, if you can go back to the map slide, Michael. Let me just reinforce something that Thiru said. This choice plan was super popular. Right? The families of color from the South End who did not want to, go back a few more, just leave it for the moment there, didn't want their kids to go to North End schools. The patriarchal school district was telling them, take the 1.5-hour bus, right? It was very popular within minority community, within low-income community, that they got to choose. And there was really compelling data on sort of the shopping habits of low-income families of color, how they shop for schools, which is very different than white families, which none of us expected. We were going to find out, but the data was compelling. This was very popular in the white schools because you could go to their neighborhood school. They had been fighting for that for years. So it was very popular. I personally had to go out. I think I did 75 PTA meetings in 1 year. Talking about this, because again, we weren't just talking about choice, we were talking about the funding model, which in many ways was more controversial, right? Because if they knew the money was going to be leaving the school, that was quite controversial. But again, if you can explain it within the context of we value diversity, we value choice, we want high quality everywhere in the district, you can frame a set of values that you can call people to. Now, anybody that simply is in it for them and their kids, they don't really care a word I say, right? But if you could at least talk to a parent population that could see we're building a school system for 50,000 kids in 100 school buildings, and you could articulate a point of view. No, I'm a believer that as a leader, if you're not prepared to go, to that PTA meeting with 20 people in the audience and they get to talk to you directly and you've got to answer their questions, that's how you connect.
So, now I have a question.
Yeah.
Drew, this is for you. You said this is probably the most consequential decision of, let's say, the 21st century. Maybe doesn't quite rival Brown, but at least for this century. But does it anticipate the Harvard case? Would you say that really this was a signal that the court was about to move away from the Grutter decision, although we get the Fisher decision in the meantime, but is this a signal that's coming down more broadly in higher education?
The short answer is yes, it certainly was on the horizon. And I actually think a number of the sort of legal hyper analytical points that Justice Breyer made in his opinion were meant to guard against what was coming. When you say, if a policy is meant to create more integrated systems versus more segregated systems, that policy ought to be subject to a different level of rigor. It was partly because if something is subject to strict scrutiny, Justice once said strict scrutiny is fatal in fact. It's very rare. I mean, there's a very small number of cases that have overcome strict scrutiny. Brown was one of them. The Michigan cases were one of them. And so not acknowledging the goal as a part of the rationale meant that when the Harvard cases and other cases like that came down, you were inevitably facing a very steep climb to justify doing it. I also think that, the question that was asked before about the complicated demographics of places like Seattle were also a part of what was going on, right? You started seeing Justice Kennedy's receptiveness to that kind of what I call it overcomplexification, because yes, it's not black and white, but you don't get to say because it's not black and white, we can draw no lines at all. Mm-hmm. And I think that people have gotten a chance to sort of exploit that in places like the Harvard case by saying, look at the certain demographics that are burdened by these results. I don't know. I mean, I think it is a very difficult position to put schools and school districts in that are trying to create meaningful diversity, knowing what is not maybe easy to put down on paper, but we all know, in fact, we know what a diverse room looks like. And if it's got a whole room of South Asians and 2 Black people, that's not diverse, even though there may be other ways to say they are similar. And I do think that challenge of figuring out what diversity looks like in a place like Seattle versus a place like Louisville, Kentucky, which was much more black and white, it was much more like a place like Baltimore, I think is one of the challenges.
Well, you can fact check me on this, Thiru, but I think Justice Roberts had some quote of, the way to quit being racist is to quit on basis of race, right? And nice bumper sticker, but we have been pushed at various times to go to, socioeconomic diversity. just free and reduced price lunch is, you make the black-white divide be not free and reduced lunch, and you aim for diversity across that. I said, our societal problems are bigger than simply poor and rich. There's a racial and cultural element to our societal problems that we want to address through school systems, and creating fluency, cross-cultural fluency in young people is critical, and it's a role that a school district could and should play. And so we're not doing enough if we create schools that are all white, but have a mix of low income and high income people, or all South Asians, but there's some low income and high income. I don't think we've done our job to create that sort of rich cultural learning environment that a school district like Seattle, but I would argue increasingly around America, the polyglot nature of race is becoming more of a norm. And so I disagree. I mean, humbly disagree with Justice Roberts. I think race is a significant part of the issue, and we do need to address it. And if you frame it as diversity, as a value, as an academic value, as a learning opportunity, as a cultivating sensitivities in young people, yeah, then I'm for that.
I in my introduction to the book, I called it sloganeering. This sort of bumper sticker approach to the way to stop discriminating is to stop discriminating. I got to read this because I thought Justice Breyer's dissent was incredibly important. Justice Stevens has an answer to this that I thought was so effective. He said, in response directly to the way to stop discrimination is to stop discriminating, he said, "This sentence reminds me of Anatole France's observation, quote, 'The majestic equality of the law forbids rich and poor alike to sleep under bridges, to beg in the streets, and to steal their bread.' The Chief Justice fails to note that it was only Black school children who were so ordered. Indeed, the history books do not tell stories of white children struggling to attend Black schools. In this and other ways, the Chief Justice rewrites the history of one of this court's most important decisions." It's just not that simple. And I think one of the reasons I would go back to what I mentioned before about the importance of allowing local superintendents and school boards to wrestle with these problems is every different community's problems look very different. It's not just Seattle versus Louisville. I mean, literally you go from one county to another. In Howard County, Maryland, they tried to rezone, to try to draw lines differently to address the problem that some of the hyper successful schools had essentially all, they had diversity, I call it. They had East Asians, South Asians, and Jewish people. And they tried to draw that over again, and it became very controversial. I think one of the great features of the Seattle program was to use choice, because choice is a little bit easier to sell than here's where the map looks like, and this is what school you're going to go to as a result.
Yeah, I have been in a number of school districts around America. Hawaii is a fantastic case study of this premise, because every other school district in America, you keep score of the racial composition of schools based on white, Black, Latino, Asian, Native. That's your population. You go to Hawaii, that's irrelevant. And they have, I think, just the Asian category alone, I think they have 7 categories that they track the ethnic composition of schools. And as a result, they think about race, ethnicity, diversity in a very different way than any other state.
Okay. Do I get another one? Marty, you have another question?
Right. So I guess I'll like you, I'll push on the how consequential was this? No problem. How consequential was this decision angle? And maybe you've already answered by saying it was really a precursor for other decisions that would come later. But you said this is affecting 3% of applicants in Seattle. Seattle is actually relatively unique in being a center city urban district that has a racially diverse student population
and prosperity in the center city.
But even there, this is operating a little bit on the margins in the
Mhm.
background, you might
Yeah.
say, of a choice system. And most school districts are already quite segregated because the segregation is between districts rather than within it. So this really only applied to what a single district can do on its own with its own schools, which is often not very much. So, I mean, given Milliken, how consequential was this? And shouldn't we be giving the talk about Milliken rather than this one?
You weren't here earlier in our thing where I said, I often call Milliken versus Bradley one of the 5 most consequential decisions of that century. I think it was profoundly difficult to overcome the challenges of segregation when you could no longer cross city county lines because people move. And I don't know where I would stack up these two. What I would say is this. There are school districts across the country that face this problem. And the most natural solution is to take account of race. Because what Justice Kennedy really was stopping us from doing was taking meaningful account of race. So if you have to literally be colorblind in how you come up with solutions, and one of the solutions that Justice Kennedy proposed was, well, when you next build your next high school, just build it in a place that's right on a fault line, and then you'll get black and white people to go to that school. Voila. The problem is
written
that-
by someone who was never a superintendent,
Correct.
right?
And who doesn't realize that schools get built once every decade or two, and then people move. And so as a practical matter, if you say that the very school districts that once turned their back on integration, but are now today striving for it, they want their children to go to schools with people of different backgrounds. If you stop them from taking account of race, I do think it limits the results. And when I said before that there are 4,000 more schools that are 99 to 100% Black and Hispanic, that's a problem. And in places like Baltimore, where there are 3 schools that are, you might call meaningfully integrated, but all of the other schools are 99 to 100% Black. Those schools, of course, are also the ones that face the highest degrees of crime and the highest levels of illiteracy and every other problem that you associate. The notion that we can pretend like these two problems are not connected, that is, the racial composition of a school and the success of that school, is just a blink reality. And I'm not optimistic about our ability to do it because the law no longer enables school districts to meaningfully wrestle with it. I said this before, I will repeat it here. I think your best hope of getting more integrated schools is to get more integrated communities, to get more diverse housing
Residential,
typologies, right?
right.
And so if you look at the places like planned communities like Columbia, Maryland, where off of one major artery, you have side streets that have both single family homes on one side and on the other side, apartment complexes and row houses, as a way of forcing people of different socioeconomic backgrounds, you do, as a result of that, sometimes get integrated schools, but it's a really backdoor and slow way to try to address a problem that is here and now.
So let me pick up on the consequential question. The consequence of a ruling like this, sure, it plays out in conference rooms at Harvard and at law firms and all that sort of stuff. Where it really plays out are cubicles at school districts. I mean, in 1996 and 1997, I had a group of 3 of us, and we were trying to brainstorm how we ended that, what could we build as an alternative to the desegregation plan we had. And absolutely, we would invite deseg lawyers like Thiru to come and counsel us on what was the legal landscape. I can tell you, if it's the Cambridge school system or the Newton school system or a Vermont school district, and they're thinking about their student assignment plans. Yeah, there's a group of wonks in a cubicle, and they're dealing with the concept. They say, well, if the Seattle case, if that wasn't narrowly tailored, then what can we do? So that's where I would argue you get, a big consequence.
And if I can just add one thing about how it sort of compounds the challenge. So, I went to a high school that was majority Black. My father taught at a school that was 99% Black, Frederick Douglass High School, which happens to be where Thurgood Marshall went to school. So the school that Thurgood Marshall went to, the school where the lawyer who argued Brown versus Board of Education and wrote this dissent is today basically devoid of white students. Imagine Baltimore City said, you know what, this is terrible. And what we're going to do is provide triple the resources to Frederick Douglass High School. And we're going to try to figure out a way to attract in a school choice model some white students to come to this school. If they couldn't also say, look, if this actually works and 20 white kids enroll in Frederick Douglass High School, but there's another 50 Black kids that now want to come to Frederick Douglass High School, and we can't put a premium on the fact that a white student actually wants to come to Frederick Douglass High School, that is really disabling of the school district's ability to come up with a realistic and practical solution. So even if you have more resources at Frederick Douglass High School, if you don't realize that that means that the Black kids at Edmondson are going to want to go there, that doesn't solve. You have to be able to open your eyes and see the practical realities if you're going to try to solve it.
Okay, so I have my class. Is I agree that there's a strong case for not having judges decide these kinds of things and leave it to the people, right? They let the democratic process resolve a lot of as many things as possible. So that makes me think that Justice Breyer might now sign on to Dobbs.
Say more for the audience.
Well, so in the case of Dobbs, you have a lot of differing opinions in the country as to the appropriate way of handling abortions and how much choice should be allowed and whether it should be what trimester is the right one to draw the line on. And there were many, many decisions by the courts on whether it should be here or there, 15 weeks or whatever. And it sounds like a lot of, brain power was being applied to something where you couldn't draw lines very clearly. And so finally, the courts decided that let's leave it up to the people, each in their local community to decide this. We know we have a heterogeneous society and people disagree on this strongly, bitterly, intensely, powerfully. So why not just let each community decide as they see is appropriate?
I'm very confident Justice Breyer would not support Dobbs. We say that.
I mean, is that a states' right argument there? Is that
there's a number of different ways to frame it. I was just curious how the professor would frame it. And I would sort of point to two things. Every one of these principles has a limiting principle. If this country decided because of diversity that we were going to go back to saying Black people couldn't go to certain fountains and white people couldn't go to certain schools, we would say that majority rule has hit its constitutional limit. The right of reproductive rights, the liberty of reproductive rights is one of those ensconced limits on what people get to decide. The people don't get to decide what a woman gets to decide to do with her body is the way you have a limiting principle. But there's a second piece of this. There was a companion set of cases that went to the Supreme Court that had to do with the 10 Commandments controversy, whether or not the 10 Commandments was permitted on state property, whether or not you could have it in front of the Texas Capitol building. And there were two cases that went to the Supreme Court, and Justice Breyer ruled differently in the two cases, and therefore his vote became the winning vote in both cases. And he made a very, one might argue, a trivial distinction. He said, if the 10 Commandments statute has been there for a long time, then it gets to stay. If it's of relatively recent vintage, it's got to go. And people said, what? How can that be the distinction about whether or not it is constitutional or not, whether it violates the First Amendment's religious clauses or not? And the explanation was that one of the goals of the Constitution of the court ought to be to avoid sectarian conflict. And if it's been there for a long time and people are not fighting about it, let's not reopen that fight. But if somebody has brought it to the fore, that risks creating rifts in communities and society that are very difficult to repair. Dobbs is an example of that. We had settled this question to the discomfort of many for a very, very long time. And there is value in stare decisis. There is value in precedent. But the notion that the moment a two-justice flip happens, that the canonical rules that govern our country can be turned on their head, I think that means that the Supreme Court is suddenly reduced to just another political organ. When you take the oath of a Supreme Court justice, every one of them got asked about Roe versus Wade, and every one of them said, I would honor the precedent, because that's apparently the right answer to give during Senate confirmation proceedings, but not actually what they believe. And I think if you have justices that say, oh, I'm going to support precedent, but then as soon as they get there, within a matter of 18 months, they reverse one of the most bedrock controversial cases, you ignite the kind of sectarian conflict that I think Justice Breyer would want to avoid. When Roe was originally decided, you mean? Yeah, look, I mean, there was a period of our nation where we were identifying rights that weren't as explicitly written as some might want. And if you look at those years, I think the students of history, the students of law would say that that was a different vision of a constitution. It didn't go as far as some might want. We talked about before that Justice Marshall lost in a 5-4 decision in San Antonio versus Rodriguez, whether we have a right to an education. It's not explicitly written. 4 justices thought it was implied by the Constitution, but Justice Marshall was in dissent. The notion that the only rights that are included and protected are the ones that are so explicitly written, and that the Second Amendment's meaning can morph over time, but the substantive due process clause of the Constitution can't grow even a little. I think that's a pretty ends-oriented rationale. I think we all acknowledge, Justice Scalia and Justice Breyer, that we have to keep with the times. And that means that rights that were written literally hundreds of years ago take different meanings in different contexts. And I think in the period of Roe versus Wade, and along with a progeny of other cases that have everything to do with birth control and everything else, the notion that it was just the Constitution and nothing more that was implied by our framers, I don't think that that's what our framers intended.
Well, thank you very much. It was
Thank you all.